Imagine having your vote diluted or denied simply because of your race. In 1965, after peaceful marchers in Selma were beaten on Bloody Sunday, America responded by passing the Voting Rights Act, or the VRA, a law to ensure the first and most vital of all of our rights, the right to vote, is protected. Section 5 is used to force states with a history of discrimination to get federal approval before changing their voting laws, essentially stopping a lot of shady tactics before they ever reach the ballot box. But today, decades later, the right to vote is under siege once again. The Supreme Court has gutted key parts of the VRA and now has its eyes set on Section 2, the last major line of defense for fair voting rights. Hi, my name is David, and this is Rights and Realities, where the law meets real life. This video will dive into what Section 2 is, why it's so important, and the high-stakes battle unfolding to preserve it. So what is Section 2 of the Voting Rights Act? Well, Justice Elena Kagan, who was appointed by former President Barack Obama on May 10, 2010, said in 2021, quote, "The court decides this Voting Rights Act case at a perilous moment for the nation's commitment to equal citizenship. Efforts to suppress the minority vote continue," end quote. Section 2 of the VRA is a permanent, nationwide ban on any voting rule or electoral practice that discriminates on the basis of color or race. In plain language, no state or locality can pass voting laws that result in denying or abridging the right to vote because of race, even if the discrimination was not overt or intentional. This provision is often called the heart of the VRA today, especially after other parts have been weakened. Unlike Section 5, which only covered some states and expired unless renewed, Section 2 applies everywhere, all the time. It's enforced through lawsuits. If voters can prove a law results in less opportunity for minority voters, courts can strike it down. Enacted in 1965, originally, Section 2 was similar to the 15th Amendment, banning intentional denial of voting rights. It was rarely used at first, since Section 5 pre-clearance was doing the heavy lifting. It was amended in 1982. Congress bolstered Section 2 after the Supreme Court weakened it in Mobile v. Bolden of 1980, which limited it to intentional discrimination. The 1982 amendments made clear that proof of discriminatory effect, not just intent, is enough. This transformed Section 2 into a powerful tool to challenge modern tactics like racial gerrymandering and at-large elections that dilute minority voters, even if officials never admit to racial intent. Why Section 2 matters. Starting in the 1980s, Section 2 litigation led to huge gains in representation for voters of color. By the early 1990s, hundreds of cities, counties, and school boards, especially in the South, were forced to abandon discriminatory at-large elections and create fair districts. For example, places that never elected a Black or Latino candidate finally saw diverse voices win office. After the 1990 consensus, several southern states had to create their first majority Black congressional districts since Reconstruction. In short, Section 2 opened the door of government to communities of color who had been shut out. The results were swift and transformative, notes the Brennan Center, as many Jim Crow-era barriers fell. You're probably wondering, how does Section 2 work? I'll show you how it fights subtle discrimination. Section 2 is powerful but hard to use. The law doesn't guarantee any group a win. It requires a demanding legal test to prove a violation. Courts follow the Thurnberg v. Gingles of 1986 framework. Number 1. Sizable and compact minority population. A minority group must be large and geographically compact enough to form a majority in a single district. No racial gerrymandering, creating bizarre districts just to add minorities. The proposed district must be reasonably drawn. Number 2. Political cohesion. The minority voters tend to vote similarly. They have common political preferences. Number 3. Block voting by majority. The white majority voters usually vote as a block to defeat the minority's preferred candidates. Number 4. Totality of circumstances. Even if the first 3 preconditions are met, a court still looks at the overall conditions: history of discrimination, racial appeals in campaigns, disparities in education, etc., to confirm that the minority's political power is unfairly hindered. Only if all of these hurdles are cleared will a court order a remedy like redrawing districts or changing our voting rule. This means Section 2 cases target truly egregious situations of racial exclusion. It's not about guaranteeing minority wins. It's about giving minority voters an equal chance. As the Brennan Center explains, there are many sizable minority communities that still can't win a Section 2 case because these strict conditions aren't met. In other words, Section 2 only bites when the deck is stacked so much that minority voters consistently lose due to race-based vote dilution. Section 2 in action, past and present. There has been historical success stories with Section 2. It's been used to strike down voter suppression schemes old and new. In its early years, it helped eliminate remaining tactics like at-large city elections that prevented black neighborhoods from ever electing one of their own. More recently, it has tackled voter ID laws and cutbacks to voting access. 3 examples of this are, number 1, North Carolina's Monster Law of 2013. Within weeks of the Supreme Court weakening the VRA, North Carolina passed a law cutting early voting, requiring a strict photo ID, and more. A federal appeals court found it targeted black voters with almost surgical precision. The court struck down key parts of the law as an intentional discrimination and violation of the 14th and 15th Amendments. Number 2, Texas voter ID law from 2011 to 2017. Texas strict ID laws was blocked by VRA's pre-clearance initially. After that protection fell, the law went into effect and was battled in courts for years under Section 2. Courts found it had a discriminatory effect on Latino and black voters, and Texas was forced to soften the ID requirements in a settlement. This took multiple election cycles, proof that lawsuits are a slower, costlier way to protect rights than the older pre-clearance system. Number 3, redistricting of Alabama in 2021. Alabama's legislature drew congressional maps that crammed most black voters into one district, District 7, and split other black communities among several majority white districts. Black voters sued under Section 2, showing that a fair map could include 2 black majority districts. In 2023, a 3-judge court and even the conservative Supreme Court agreed Alabama's map diluted black votes in a violation of Section 2. This case, Allen v. Milligan, was a surprising victory for Section 2, reaffirming that the law still has force even in redistricting. What is the difference between Section 2 versus Section 5? It's important to note that Section 2 is reactive, while the old Section 5 was proactive. Under Section 5, states with a history of discrimination had to get approval before changing any voting laws. This blocked many bad laws from ever taking effect, but in 2013, the Supreme Court's Shelby County v. Holder decision struck down the coverage formula that determined which places were subject to pre-clearance. Chief Justice John Roberts, for the Supreme Court's conservative majority, famously said, quote, "Our country has changed," end quote. He noted higher minority voter turnout and felt the 1965-era pre-clearance rules were no longer justified. On the flip side, Justice Ruth Bader Ginsburg, in dissent, warned that ending pre-clearance was like, quote, "throwing away your umbrella in a rainstorm because you are not getting wet," end quote. In other words, the VRA's success in protecting voters was precisely why it is still needed, but the court prevailed, and suddenly, states like Texas, Georgia, and North Carolina, previously under a voting change timeout, were free to enact laws without federal oversight. The rainstorm quickly returned. Within 24 hours, Shelby, Texas announced its stricter voter ID laws previously blocked would go into effect. Dozens of formerly covered jurisdictions moved polling places, purged voter rolls, or changed rules in ways that hurt minority voters. Section 2 became the only tool left, but it meant after-the-fact lawsuits. These take years, during which elections happen under the biased rules. For example, Pasadena, Texas switched to an at-large city council to dilute Latino voting power right after Shelby. Latino citizens did win a Section 2 case to reverse it, but it took 4 years of litigation and several elections under the unfair system. This demonstrates a key point. Section 2, while vital, is a slower remedy that often comes only after harm is done. Modern battles, voter suppression, and Section 2 challenges. In recent years, new voting restrictions have swept across states under the banner of election integrity. Many of these, like stricter ID requirements, cuts to mail-in voting or drop boxes, reduced early voting, etc., which in turn disproportionately impact voters of color. Section 2 has been invoked to challenge such laws for having racially disparate effects. However, the Supreme Court in 2021 made that harder. Brennan v. DNC 2021. In Brennan, the Supreme Court reviewed 2 Arizona policies, one disqualifying ballots cast in wrong precincts, and another banning ballot collection, against third parties collecting ballots, practices that minority voters used more often. The conservative majority, 6-3, upheld both rules, and in doing so, announced new guideposts that tilt Section 2 cases in favor of the state. Justice Samuel Alito's opinion said, courts must consider, for example, the unusual burdens of voting. A law isn't illegal just because voting isn't effortless. Minor disparities in impact or mere inconvenience to voters likely won't violate Section 2. He also notated that if a state's whole system is relatively open, meaning lots of other ways to vote, one restrictive rule might not be enough to prove a Section 2 claim. Justice Elena Kagan wrote a blistering dissent. She accused the majority of rewriting in order to weaken a statute that stands as a monument to America's greatness, turning the VRA into a pale shadow of itself. Kagan pointed out that this decision came at a perilous moment when too many states are restricting access to voting in ways that will predictably deprive minority groups of equal access. In essence, just as a wave of voter suppression was happening and hundreds of new restrictions across states was rising, the court raised the bar for Section 2 challenges. Voting rights advocates say Brennan considerably weakened Section 2. It's now harder to win cases against things like purging voter rolls or limiting ballot drop boxes because states can argue those are normal burdens or point to other opportunities to vote. Still, Section 2 isn't dead. It remains usable, especially in redistricting cases, which Brennan didn't involve. But the trend is clear. The court's conservative majority is skeptical of expansive voting rights protections. The Supreme Court showdown, Section 2 on the line. Now we arrive at today's critical fight. In 2023 and 2024, a series of cases, especially one from Louisiana, put Section 2 itself in the crosshairs. The case, Louisiana versus Callis, was initially about whether Louisiana's congressional map violated Section 2 by diluting black voters' power, very similar to the Alabama case. A lower court had ordered Louisiana to add a second black majority district since 1/3 of the state's population is black. Instead of complying, Louisiana's legislature, led by Republicans, resisted, and a group of white voters sued to block the new map. Their arguments was startling. If Section 2 requires creating an extra black opportunity district, then Section 2 itself forces an unconstitutional racial quota. They claim the VRA is making race too large a factor in redistricting, conflicting with the equal protection principle of a colorblind constitution. In essence, they assert Section 2 equals reverse discrimination. This is a bold bid to strike down or severely limit Section 2, and alarmingly, the Supreme Court agreed to hear this broad question. On the last day of their 2024 term, the Supreme Court announced it would rehear the Louisiana case, focusing on whether Section 2 remains constitutional. This is unprecedented. For 60 years, Section 2's constitutionality wasn't seriously doubted. It was renewed by Congress multiple times with huge bipartisan support, most recently in 2006, 98-0 in the Senate. But the court's conservative supermajority, 6-3, has shown willingness to uproot long-standing precedents. During oral arguments October 2025, several justices seemed sympathetic to cutting back Section 2. Louisiana's lawyer bluntly argued that if Section 2 requires race-based redistricting, it is unconstitutional. Justice Brett Kavanaugh considered a swing vote on this issue, said the DOJ's proposed compromise would limit the use of race in VRA remedies. He said, quote, solves a lot of concerns, end quote. He appeared open to at least narrowing the Gingles test or requiring plaintiffs to clear new hurdles. Meanwhile, Justice Ketanji Brown Jackson, the first black woman on the court, passionately defended Section 2 in the arguments. She explained that Section 2's purpose is to remedy the disadvantage minority voters face due to the legacy of discrimination. She says, quote, the government is responding to current-day manifestations of past and present discrimination to make it so minority voters have equal access to the voting system, end quote. Her point considering race and voting remedies isn't about giving unfair advantages, it's about addressing long-standing inequalities in access and representation. In context, she compared Section 2 to something like wheelchair ramp access, a tool to ensure everyone can reach the same door, not a shortcut for anyone. So you're probably wondering, what are the potential outcomes from the court in mid-2026? Well, number one, further weaken Section 2. The court might not strike it down entirely, but could adopt a new test, like the Trump's DOJ proposed rule, that made Section 2 cases almost impossible to win. For example, requiring proof that a state intended to discriminate or that race, not partisanship, was the sole cause of a map's design. Given how politics and race overlap, over 80% of black voters vote for Democrats. That kind of standard would let states shrug off most challenges. As Professor Spencer Overton warned, such an approach would, quote, effectively gut Section 2. Cases would exist on paper, but be nearly impossible to win, end quote. Number 2. Eliminate Section 2 for redistricting. The court could rule that in redistricting, Section 2 cannot require creating majority-minority districts, calling that affirmative action for politicians. They might say the Constitution forbids drawing districts based predominantly on race, even to remedy dilution. This would neutralize Section 2 in exactly the area where it's been most impactful, electoral maps. States could claim any attempt to add a minority district is unconstitutional racial gerrymandering, effectively ending minority representation gains. Number 3. Uphold Section 2. It's still possible, though many are pessimistic, that the court, as it did in 2023's Alabama case, hesitate to destroy the last pillar of the VRA. Perhaps Justice Roberts, who cares about the court's legacy, will cobble a narrow decision that preserves Section 2 but leaves questions for another day. Voting rights advocates like the ACLU's Sarah Brennan hold on to hope but are preparing for the worst. The most dramatic outcome would be outright striking down Section 2 as unconstitutional. This would be a legal earthquake, the court effectively saying Congress exceeded its power in protecting voting rights for minorities. Louisiana's Solicitor General urged this, arguing Section 2's requirements themselves violate the equal sovereignty of states and equal protection of individuals. If that happened, it would mean the end of the Voting Rights Act's core. Voters of color would lose their primary tool to challenge discriminatory voting laws in federal court. So what's at stake if Section 2 falls? And why does this abstract legal fight matter? Because without Section 2, voters of color will have far less protection against voter suppression or gerrymandering. Here are the real-world consequences if the court cripples Section 2. States and cities could slice up minority communities at will. For example, without Section 2, the case forcing that second black district in Alabama never could have succeeded. Alabama's map, with only one black district out of 7 and a 27% black state, would stand. A report found that eliminating Section 2 could let Republicans redraw up to 19 U.S. House districts to their advantage, likely by dispersing minority voters and diminishing their influence. This isn't just partisan, it means communities, Black, Latino, Native, Asian American, would effectively lose representation in Congress and state legislatures, reversing decades of progress. At the local level, the impact could be even more severe. Many city councils, school boards, and county commissions could switch back to at-large elections, where the majority can win every seat, knowing Section 2 lawsuits can't stop them. The Brennan Center reports 2/3 of Section 2 cases have been at the local level, often to fight such schemes. Without Section 2, jurisdictions might resurrect old tricks, like moving polling sites out of minority neighborhoods, consolidating minority districts with majority ones, or implementing burdensome voting rules with little fear of consequences. We could see a wave of backsliding, what Ginsburg called second-generation barriers, more subtle but effective tactics to exclude minority voices. Individual voters could have to rely on costly, slow lawsuits under the Constitution, proving intentional discrimination, which is very hard. The Justice Department's Civil Rights Division would lose a key statute that it has used to enforce voting rights nationwide. While some states have their own voting rights acts, many, especially those with histories of suppression, do not, meaning millions of Americans will be unprotected by any similar law if Section 2 is gone. In practical terms, weakening Section 2 favors those currently in power, often white and/or one political party, at the expense of emerging minority communities. For instance, if Section 2 had been nullified earlier, places like Ferguson, Missouri might never have had to revise election systems that locked out black voters. It took Section 2 cases to bring change. An adverse ruling now could freeze progress and even turn back the clock on representation for a generation. Sarah Brennan of the ACLU warns, quote, if the court further weakens Section 2, states and localities with long histories of discrimination could be free to draw maps that systematically silence Black, Latino, Native, and Asian American voters, end quote. It would be an open season for gerrymandering under a race-neutral guise, basically doing the same discriminatory mapping but claiming it's just politics as usual. Conversely, those who support the challengers claim they want a colorblind system. They argue the VRA, as interpreted, gives special treatment to minority voters. One attorney even quipped, "It's like affirmative action for politicians," but this ignores a crucial reality. We still have racial voting disparities and polarized voting in many areas. Justice Kagan put it plainly. She says, quote, "Efforts to suppress the minority vote continue. No one would know this from reading the majority opinion in Brennan," end quote. The need for Section 2 remains, as Congress itself found with mountains of evidence when it reauthorized the VRA in 2006. Nearly 60 years ago, the Voting Rights Act was passed because of the courage of civil rights activists and the undeniable truth that democracy was failing Black Americans in the South. President Lyndon B. Johnson told Congress, "It is wrong, deadly wrong, to deny any of your fellow Americans the right to vote." And he declared, "We shall overcome," making the cause of Selma his own. Section 2 was and is a promise that every voter's voice counts equally, no matter their race. Today, that promise is being tested like never before. The Supreme Court's forthcoming decision will determine whether Section 2 remains a meaningful shield or becomes an empty symbol. But no matter what the court decides, the fight for voting rights will continue in Congress, in state legislatures, at the ballot box, and in the streets. As Justice Ginsburg reminded us, the VRA's protections are vital to prevent backsliding. And as Justice Jackson implied, our country can't move forward by ignoring the racial inequalities of our past and present. As the late John Lewis said, "The vote is precious, almost sacred. It is the most powerful, nonviolent tool we have in a democratic society." Section 2 of the Voting Rights Act is about keeping that precious tool in the hands of all Americans, not just the privileged few. The story of voting rights in America has always been one of struggle and sacrifice, from Selma, Edmund, Pettus Bridge to court battles in our own time. We must decide whether to carry that legacy forward or let it slip away. Thanks for watching Rights and Realities. Now I want to hear from you. Do you think Section 2 of the Voting Rights Act should be weakened or protected? Drop your thoughts in the comments below. If you found this video helpful, hit the like button and subscribe for more content where I break down the law and show how it impacts real life.